for the peace, order, and good governance of the country, and then the judiciary for the purpose of interpretation of the laws, where there is conflict between individuals or between the federal government and the state, or between the various component states that make the Nigerian nation state. So having regard to this constitutional provision, the powers of the National Assembly, or the role of the National Assembly in the process of driving the developmental agenda of any government cannot be relegated to the background. And sequel to that, the 9th Senate, and indeed the 9th National Assembly, to which I belong to as a member of the House of Representatives, has done tremendously well in the discharge of that onerous responsibility of lawmaking for the peace, order, and good governance of the country, as clearly exemplified by the avalanche of robust and positive impact-making bills that were passed by the 9th Senate, and indeed, by extension, the 9th National Assembly, that has positively impacted the lives of the people. And just to mention a few, for example, the Petroleum Industry Act that has defied all passage by all national assemblies since 1999 has been passed by the 9th Senate, and by extension the 9th National Assembly. And the National Assembly for that deserves a pat on the back, because it has transformed the petroleum industry. And as we all know, the petroleum industry is the lifeway of the Nigerian economy, Nigeria being a mono economy that depends on oil for vast majority of its revenue. So the Petroleum Industry Act that was passed by the National Assembly has really transformed the petroleum industry, made it very competitive, made it transparent, and has attracted a lot of much needed investment to the sector, as well as the avalanche of the various constitutional reforms and electoral reforms that were passed by the 9th National Assembly, with a view to making our electoral system much more transparent and credible, so that at the end of the day, whatever decision that was taken or results that were announced is a replica of the wishes and aspirations of the people. So, looking at the various bills that were passed by the National Assembly, particularly the 9th National Assembly, and that were assented to by Mr. President, I think the 9th National Assembly deserves a pat on the back, and has kept off to its responsibility of lawmaking for the peace or good governance of the country, as per Section 4 of the 1999 Constitution as amended.
Okay, thank you very much, Senator. Now on to the 10th Assembly, of which you are a part. And of course, we don't have a crystal ball to look into and determine what is going to be in the future. But the Senate President, Godswill Akpabio, is giving something of an indication of how the National Assembly will function at the Thanksgiving in an article that was written by a veteran journalist. He's given the indication that the National Assembly will function. The current National Assembly will rally around and support the programs of the current administration by eliminating all inhibiting policies affecting the progress and development of the country. Now, that's all well and good, but there is the very reason that we have these three tiers of government. It's not for them to be opposing each other, but to remove any semblance of rubber stamping the other, so that there shall be, a freeness and a fairness, and indeed, at the end of the day, the Constitution shall be supreme. Now, in this whole question, there was a sense in which the Ninth Assembly was accused by, observers of, this whole matter of rubber stamping. It probably didn't come out as clearly as they could have, and so there is the worry that I hope this won't continue now, and that's why what the Senate President has said, that the current Assembly will rally around and support the programs of the current administration. But surely that shouldn't be willy-nilly.
The problem is that Nigerians misinterpret or have a very different perception of the relationship that is supposed to exist between the legislature and the executive. The relationship between the executive and the legislature should be a relationship that is mutually symbiotic relationship. Mutually symbiotic relationship in the sense that both the executive and the legislature were elected by the people with a view to delivering dividends of democracy to their doorsteps. In the process of discharging that sacred responsibility of delivery of dividends of democracy to the doorstep of the people, there is a need for the executive and the legislature to understand each other and then work together without necessarily either the executive or the legislature surrendering its independence to either arm of the government and then deliver dividends of democracy to the people. So this question of the National Assembly being reduced into a rubber stamp of the legislature, of the executive arm of government, does not hold water. There are instances when the legislature will rise up to the occasion and then fiercely and jealously guards and protects its independence, where there is clearly an encroachment or deliberate steps being taken by the executive arm of government to encroach upon the powers of the legislature of lawmaking for the peace, order, and good governance of the country. And that is why you can see on various occasions where there are invitations to members of the executive arm of government, whether either out of executive arrogance or executive recklessness, they refuse to honor the invitation of the legislature. The legislature invokes the relevant provisions of the Constitution and wields the big stick with a view to forcing members of the legislature to appear before the legislature to account for their acts, whether their acts of omission or commission in the discharge of the functions of their office. So this notion of the legislature has been reduced to an appendage or a rubber stamp of the executive does not hold water again, because there are instances where the legislature jealously guards and protects its independence, but without necessarily relegating to the background the need for the two arms of government to work in a mutually symbiotic relationship with a view to delivering dividends of democracy to the doorsteps of the people. And again, what people should realize is that, for example, both in the 9th and the 10th National Assembly, the APC is the majority party, while the executive arm of government is controlled by the APC. And we have a commonality of vision and programs as enunciated in the manifesto of our party that promised the people we are going to deliver by the time we are voted into government. So because of that, and the fact that we are both from the APC, both the executive and the legislature are from the APC, and there is commonality of programs and manifesto, there is consensus at IDEM at that level between the executive and the legislature to deliver dividends of democracy to the doorstep of the people. And then at a point, there was a committee that was formed, a tripartite committee consisting of the party, the members of the executive, and members of the legislature. I think the members of the executive is led by the vice president, while the party is led by the national chairman of the party, and then the executive, the legislature is led by the Senate president. There is a tripartite committee that was formed with a view to members of the executive and the legislature, since they are coming from the same party, agree on programs and objectives of government before it is brought even to the parliament for deliberations, so that we don't wash our dirty linens in the public as members of the same party.
Yes. Well, okay, that's all well and good. But at the end of the day, all tiers of government must have their eyes on the ball, which I expect, apart from, being whatever the programs are that are being put together by the executive, is the Constitution. Everything must be constitutional. And for the first time, we have eight parties. The developmental agenda of Nigeria, to which everybody will be committed, should be committed. Now, having 8 parties, that spread seems to suggest that, we have a nice mix, and so that nothing falls, as it were, between the cracks. Very little falls within the cracks, having about 8, including the ruling party, about 8 parties that are all involved in this. Managing this, I understand that this is for the first time that we've had such, such a pool. Managing this, how easy is it going to be? Because as I said, apart from the Constitution that will be governing everything, developmental ideas might differ. There's so many of them, and you can't attend to all of them. Do you think this is going to be a problem for the, not a problem, a challenge for the National Assembly, and in particular the leadership of the National Assembly, accommodating all those views, which is their right to contribute to the pot, so to speak?
It's not going to be a challenge. It is even the pluralism or multiplicity of parties in the National Assembly is even going to be an advantage rather than a disadvantage to the National Assembly, because it is going to unleash multiplicity of opinions, diversity of opinions in the course of debates in the National Assembly, so that at the end of the day, the outcome of whatever resolutions that we are going to pass will be a replica of the wishes and aspirations or broad consensus of all the component units that make the Nigerian nation state. So it's going to be an advantage to the National Assembly, and the modus operandi of working in the National Assembly is lobbying, reaching out to all representatives across parties, across the nooks and crannies of the country and what have you, so that the resolutions that are going to be passed is a resolution that is agreed upon by all.
Okay, one moment, Senator. I beg your pardon for interrupting.
But definitely,
Senator, pardon me, Senator, for interrupting. But I just wanted to bring on Mr. Awolowo, who has called in from Edo State. Good morning, Mr. Awolowo. Well, we lost Mr. Awolowo. Tell you what, maybe we should just take a break so there will be less interruptions than if we hadn't taken it. Let's take this break now, but please stay with us. Senator, we'll be right back to continue this conversation. Okay, then. Well, we're back, and our guest is Senator, representing the Borno North Senatorial District, Mohammed Tahir Monguno. And I had to interrupt. Apologies for doing so. I tried to bring in Mr. Awolowo. Unfortunately, we lost the call. But you were explaining how the wide diversity of the membership, wider diversity of the Senate would not necessarily constitute a problem. And you were given the impression that the more the merrier, since it would, accommodate a multiplicity of views. Would you like to continue, please, Senator?
Yes. Well, as we all know also, where there is serious disagreement in matters of national discourse. In a democracy, the majority will always have their way, while the minority will have their say. So, where there is serious disagreement, I'm referring to the multiplicity of parties in the National Assembly. You met an instance where there is agreement, how is it going to be resolved? I earlier on alluded to the fact that as much as possible, the merrier, the better. Our debates are going to be robust, they are going to be in-depth, and then at the end of the day, whatever resolutions or laws that we are going to pass is going to be a replica of the wishes and aspirations of generality of Nigerians. But this is a democracy. You don't expect that you will always have a consensus on issues. Where there is serious disagreement, the majority will have their way, while the minority will have their say. We, the APC, we are the ruling party, we are in majority, and where there is serious disagreement, the views of the ruling party will have its way, because we are in majority.
Okay, let me bring in Chidi. Chidi has called in from Kafanchan. Good morning, Chidi, in Kafanchan.
Good morning, Uncle Yori. Good morning, the Senator in the House.
Good morning to you, sir.
That everyone's hands must be on deck, particularly as it has to do with the National Assembly. These are people that are there on representative capacity. They should have to meet with their constituents, and they have to be regular in doing this, to have feelers from their constituents and extending them to the other tiers of government, so that they can now work synergistically in order to bring the much-needed succor and making life easy for the Nigerian people. By so doing, it will be very, very easy and prosperous to manage Nigeria's national affairs. Thank you very much, and God bless you.
Indeed. Thank you for calling in, Mr. Chidi. I hope you get more calls in, because really, we're talking about, as you said, Chidi, the representation of Nigeria divided up into senatorial zones. And as we were saying before, for the first time, we have a greater multiplicity of parties than we have had in the past. But the senator was just saying there, just before we took that call, that, well, at the, last, if it ever comes to that, then the majority will have its say, while the minority will have, the majority will have its way, and hopefully that way is the national way, while the minority will have their say recorded. But yes, we understand that that's the principle, basically, but perhaps ideally, we'd have a situation where there would have been all these kind of negotiations among parties, some of them friendly, some of them not so friendly, but all of them civil, just showing the gusto of the members of the National Assembly with Nigeria and the Constitution being the bedrock in putting across these whole ideas. That's, I imagine, what Nigeria wants, and that's what Nigeria will be watching for. And we just hope that all will go, even though you spoke well of the 9th Assembly, there still are those that felt that they would have appreciated a bit more, how does one put it now, a bit more of a pushback. I think the allegation being that quite a number of bills were sent to the executive for assent, but then they were not assented to. So the thought goes, and the National Assembly left it. Surely, if the National, for example, it's in the past now, we're talking about the 9th Assembly, the situation where if the whole House in its wisdom has put forward, a legislation to the executive for assent, and it is not done so, then it must be interrogated that the executive really has reason not to assent. Otherwise, because we're talking about the balance of powers, no one person has the supreme power, even though the executive, yes, we understand, is driving the ship.
Well, first I want to comment the caller who alluded to the fact that there is need for adequate representation and consultation by members of the National Assembly being representative of the people. I agree with him in total that there is a need for regular consultation and regular visitation to our respective constituencies so that we can have the pillars, fill the pillars of the people as to the programs and government programs that are being rolled out, whether it touches them, whether it impacts their lives positively or not. That aspect of representation should not be compromised, and it was against this wisdom that legislators are expected to open constituency offices, and they were given five number of aides to assist them towards actualization of that very important aspect of representation. And these aides, some are supposed to work in their respective constituency offices to be part and parcel of the people, hear the views of the people, and then relay to their representative in the National Assembly to guide its decision-making process. I think that is the wisdom behind constituency offices, and then members of the National Assembly should prioritize and give a lot of prominence to that aspect of representation, because that is the only way we will pass laws that are autonomous, laws that reflect the wishes and aspirations of the people. Then with regard to the...
I beg your pardon. Sorry, sir. Senator Mongono, one moment. We'll take a break. We'll be right back to continue with this. Stay with us, please. Indeed, welcome back. And our guest is Senator Mohammed Tahir Mongono. He's representing the Borno North Senatorial District of the country. And unfortunately, we lost the last caller before we went to break, Emmanuel, who had called in from Lekki. Sorry about that, Emmanuel. See if you can get in again. Meanwhile, Noel in Onitsha has called in. Good morning, Noel.
Good morning.
Okay. Go right ahead, please.
Okay, thank you. Yes, I have lots of issues to raise. One, I want to ask the distinguished on the platform on the position of independent candidacy independent candidates.
Sorry, Noah, what do you mean? I mean, Nigeria doesn't have that provision. There are no independent candidates, are there?
Yes, I mean, what's the position of the Senate?
Oh, sorry, Noel, our topic of conversation is the tough task, as it is, of fixing Nigeria and the role of the National Assembly in that. That's our subject of this discussion.
It's all right. Okay, let me go to the second issue.
Okay.
The second issue is the local government system.
I don't know if I can get some more volume here. I can't hear properly. But please continue, Noel.
The local government system. Can we say that?
Yeah. Say that again, please.
The local government system, its administration, whether it is actually a third tier of government, because when you are fixing Nigeria, you are talking about the whole entire tier, the federal, the state, and the local government. So if the local government is also part of a tier, what has it brought to the table? What has it brought to the table? Because some people are asking of its independence or it being recognized as far as the Constitution has provided that it is there. So,
okay then, Noel. I think I got you there. Well, Senator, I think still coming back to this separation of powers matter, there's the executive, there's the legislature, and there's the judiciary. But Noel has now brought in, how do you feel that there is an urgent role and need for the local government system to be, be represented in resolutions and, shall we say, just the practice of the National Assembly? In other words, I guess, he didn't say so, but I guess he's alluding to the fact that the local governments seem in our whole body of politics to be, relegated to the role of the junior partner. Sometimes they are completely ignored.
The National Assembly, with regard to the issue of autonomy of local governments, deserves a pat on the back, in the sense that for about 2 constitutional amendment exercise in the 8th Senate, in the 8th National Assembly, and in the 9th National Assembly, the National Assembly passed a resolution for constitutional amendment to the effect that local government should not only be seen to be autonomous, but should be manifestly be seen to be autonomous in all senses. And that resolution was passed by the 8th National Assembly and the 9th National Assembly, to which I am part and parcel, without a voice of dissent. But for the fact that there is need for concurrence by various state houses of assembly for it to be passed, by the time it went to the State House of Assembly for their concurrence, it did not see the light of the day. So for the National Assembly, it has jealously guarded and protected the issue of the independence and autonomy of local governments against the backdrop of the fact that this is a tier of government that is very close to the people, and if it is properly allowed to function and energize, it has the capacity of bringing about delivery of more dividends of democracy to the doorsteps of the people. With regard to the various mundane issues of governance, like pipe-borne water, sanitation, good quality education at the primary school levels and whatever. These are issues that are supposed to be attended to by the local government if granted the proper autonomy. So the National Assembly deserves a pat on the back with regard to the issues of the autonomy of local governments, because it has passed those resolutions twice without a single voice of dissent, but it was not concurred to by the State houses of assembly. So the caller from, I think, Onisha should take up the issue with his members of the state houses of assembly, Anambra State House of Assembly.
Well, that was Noel. That was Noel calling in from Onitsha. Thank you very much, Senator. Mazi Okoroafo from Arochukwu is waiting on the line. Good morning to you, Mazi.
Good morning, sir. Honestly, sir, you see, the National Assembly has a lot to do. A lot in the sense that if the promises they gave the constituency where they come from, they have started fulfilling it now, Nigeria will not be complaining about palliative or no palliative. You see, they have a manifesto. Everybody has to manifesto. I was expecting them, when they saw what was going on about this issue of 5 billion to governors and federal capital, that they could have gone back to their president research, and this one are still in Abuja. Go back there, at least you have the zone officers, you have the zone offices. Sit down, let the people there they have employed to work for you, gather the things that they're supposed to hear, and tell you. Now, 80% or 90% of schools, which is the local government handled schools, that is the basic education, which is the primary and or junior secondary school now, are being handled by the local government authority. At least I was suspecting the other way, madam, knowing fully well that education is paramount important for anybody in this world. They're supposed to go there and find out where can we come in to cushion the fence so that we help people them to go back to school. But nobody cares. Palliative is not the ultimate. Palliative is not, when they like bring food and give to somebody tonight, you have got to give that person. It's not like taking a horse to the stream. You can take a horse to the stream. You cannot force that horse to drink water. That is what it means. But the shikar now, because 2022 is around the corner. But what I'm just calling is that now you see the labor people are convinced. Now look at the federal government, please, people have to hammer on this issue. The federal government declared issued a statement that no universities, polytechnic should increase school fees. Now, research has shown that 90% of schools in Nigeria, federal universities, have increased their school fees. Their tuition have increased it. Not to talk about the state. Now, tell me, the policy which the federal government issued that no schools should increase, and they have done that. And people are sure. Then people call the same and say, what is happening? That the school fees is I'm not in the school there. You should find yourself, find out the solution, what is happening. They say that the school has increased. Tell me, the school is still corrected. All the universities, what do we do? And we have National Assembly members. They said they have discovered they've got the vice chancellors to come and they should make that report open. Let the vice chancellors tell us what is happening with the money that they get them. They have 80% of courses in Nigerian universities have not been accredited. I repeat, have not been accredited. National Assembly finds solution to that. Many students have graduated. They cannot go for NYC because the courses that they told them to treat that before they graduate are not accredited. It's affecting the parents. You spend your money to train your child for 5 years, 6 years, 7 years, 4 years. At the end of the day, the courses are not accredited. And we have a state, we have a country, we have people that are there. Vice chancellors, what are they doing? Yes, where are you? Go and find, yes, where are you? Go and find out what is happening.
Okay, Mazi, let me bring it to the senator. I beg your pardon, Mazi. Thank you very much for calling in. Senator, I guess this leans towards the oversight function. We've spoken about, it's not just legislation, but there's also oversight. In other words, the National Assembly has to keep an eye on what's going on in the polity and can step in, especially if represented to, or if it itself, has noticed that there is anything that needs urgent consideration, urgent address. And I guess what Mazi Okoroafo was talking about there might well qualify. How do you see it? Does the National Assembly have the capacity so to do?
Well, the National Assembly, as you rightly pointed out, also has, as per the Constitution, the power of oversight on all ministries, departments, and agencies of the government, with a view to not only tracking the budget implementation and also making sure that all the policies and programs that were being executed by various ministries, departments, and agencies are in tandem, not only with the extant laws establishing them, but all other laws and the Constitution of the Federal Republic of Nigeria, which is the grand norm of the land. And it was sequel to that the National Assembly is divided or constituted into various committees for ease of oversight on various ministries, departments, and agencies. For example, in the 7th House of Representatives and the 8th House of Representatives, I was the chairman of the Committee on Agriculture, and sequel to that, we have gone to all the nooks and crannies of the country for the purpose of oversight to see whether the budget is being implemented to the letter with a view to positively impacting on the lives of the people, and to see whether all the agencies of the government under the Ministry of Agriculture are working in tandem with the extant laws that establish them or any other law that is in existence in Nigeria. And the National Assembly religiously carries out that responsibility of oversight, as you can see in our various media stations, where members of the National Assembly have gone on oversight, sometimes question the way and manner some projects were executed, and then give appropriate advice to ministry, department, and agencies, to which advice were adhered to, and then various programs were executed in tandem with the Appropriation Act. And in the present, for example, in the 10th Senate, of which I am a member, I am the chairman of the Committee on Judiciary, Human Rights, and Legal Matters. By the time we resume, we are going out on oversight to see whether the budget is being implemented to the letter in tandem with the spirits and letters of the Appropriation Act, and where it is not being implemented or where an agency has gone astray, we'll call them to order so that the budget will be implemented to the letter with a view to bringing the dividends of democracy to the doorsteps of the people. So it's a constitutional responsibility. The power of oversight is clearly enshrined in the Constitution, and sequel to that, the National Assembly was divided into various committees for ease of oversight, and the National Assembly goes on oversight sometimes through its standing committees or sometimes through the ad hoc committees that were constituted. For example, even in the 10th Senate.
Senator, before the example, so sorry, Senator, before the example, because Kasumu called in from Taraba State and has been waiting for quite a while. Sorry about that. Good morning, Kasumu in Taraba.
Good morning, Mr. Yori. How are you doing?
Good morning. Thank you for calling in.
Thank you. Good morning, our guest, distinguished Senator Bangulu.
Yes. Go ahead. He can hear you.
Okay, sir. Honestly, I really appreciate like this program. Honestly, definitely the situation in our country lies under our National Assembly. So what the senator is saying, we really need them to do the needful, because they all need our mandate from the local level that will take them to the national level. So we are talking about the local government autonomy. The local government autonomy is one of the major problems we are facing in this country. The State Assembly have passed these issues for the State Assembly to consider it and make it in the light of the day. So to me, I see this as a collaboration between the National Assembly and then the State Assembly. If the National Assembly have the interest for this motion, for this bill, for the local government autonomy to see the light of the day, have they not have the right to override the State Assembly to do the needful that will help the masses entirely?
Okay, oh, well, thank you very much. Actually, they can't, but let the senator explain how they must get 2/3 of the assent of the state assemblies in the country. Senator, would you like to address, please, Kasumo's inquiry?
In Nigeria, Nigeria is a constitutional democracy. All our actions or inactions are guided by the clear and unambiguous provisions of the Constitution. So as such, whatever we do is supposed to be within the bounds of the Constitution. As it is now, the Constitution requires the concurrence of 2/3 of the state houses of assembly for that bill to pass. And there's nothing we can do about it. That is the clear and unambiguous of the provision of the Constitution, and the Constitution did not go further to give powers to the National Assembly to override what the non-concurrence of the state houses of assembly where there is non-concurrence. So we are a constitutional democracy, our hands are tied, and whatever we do must be within the limits and bounds of the provision of the Constitution. We are not supposed to act ultra-vires the provisions of the Constitution. That is why I told the caller from Onitsha that they should hold the Anambra State House of Assembly to account if the Anambra State House of Assembly has not concurred to the provision to that amendment. So, and ditto to the caller from Jalingo, if, as per the records, the Taraba State House of Assembly has not concurred to that provision, they should hold into account the Taraba State House of Assembly, and more particularly, the member that represents him from Jalingo, whether he has voted for or against that amendment, because these are records that are supposed to be in the public domain, and whatever as representative of the people that we do in the discharge of that function should be a subject of public scrutiny. So the way and manner your representatives voted.
I'm sorry, Senator. I beg your pardon. You must forgive my apparent bad manners in always interrupting you. It's the way it is. Our last call, Mr. George calling in from Lagos. Good morning to you, Mr. George.
Good morning, Uncle Yori, and good morning to the guests. Uncle Yori, the topic of today's discussion is National Assembly and the tough task of fixing Nigeria. In terms of fixing Nigeria, we are seeing what the executive is doing. They are saying it's no longer business as usual. The president is creating new ministries and departments. The ministers are hitting the ground running. But I am not seeing the same thing in the legislative arm. What we see, rather, is business as usual. Quarrels with MPAs for not honoring invitation. You come, you have 2 days, 3 days session, you go on 1 month recess. These new departments and ministries that are being created, they need legislation. We want to see a change of attitude towards legislation in Nigeria.
Okay, let me bring I beg your pardon, Mr. George, for interrupting you too. Apparently, I'm doing it to both sides this morning. I'm so sorry to both of you. But, Senator, because we've almost run out of time, take that up, will you?
Please, the National Assembly is also equally desirous of making a change. because this 10th National Assembly is a National Assembly that is seriously desirous of making a difference in the way and manner things are done. By the time we start functioning full blast, all the differences that the National Assembly is desirous of will be seen. This issue of going on recess is something that is in our rules. It's something that is in our rules. Unless the rules are amended, definitely we have to go on recess. And this recess did not start with the 10th National Assembly. It has been the tradition since the inception of democracy in 1999. So the National Assembly has been inaugurated. Our committees were formed, constituted a day before we went on recess. By the time we come back, as initiated in our legislative agenda, we are definitely going to make a difference that will revolutionize the socio-economic dynamics of this country in tandem with the renewed hope agenda of the present administration. So
excellent.
Definitely a lot.
Actually, let me just say that I'm so sorry, Senator. Excellent, indeed. So I guess really my summary would be that what Nigerians are looking forward to, because they're looking forward to much, generally speaking, in the National Assembly, they would want indeed for you to support the National Assembly, to support the executive where necessary, and indeed to oppose the executive where necessary. Do you feel, do you think that you'll be able to deliver on that score?
Definitely. As I told you earlier on, the relationship between the executive and the National Assembly or the legislature is supposed to be a mutually symbiotic relationship, since all of us were voted into power with a view to delivering dividends of democracy to the doorsteps of the people. We have to cooperate and we have to understand each other, cross-pollinate ideas with a view to discharging that onerous responsibility of delivery of peace, order, and good governance to the people of this country. But where there is obvious or deliberate encroachment upon the powers of the National Assembly as enshrined in Section 4 of the 1999 Constitution as amended, be rest assured, I'm going to assure Nigerians that this 10th National Assembly is going to stand up its responsibility and will jealously guard and protect its independence and also stop all the excesses of the executive, whether in terms of executive recklessness or executive arrogance in the discharge of their duties. That much I assure them. But it's supposed to be a mutually symbiotic relationship, especially against the backdrop of the fact that the executive is led by the APC, while the National Assembly is equally led by the APC. So there is consensus at IDEM as to the programs and money.
Thank you. Thank you very much, Senator. I beg your pardon. Thank you very much, Senator. That's a fine place at which to leave it, and we owe you our appreciation. Senator Mohammed Tahir Mongono, legal practitioner, and Senator representing Borno North Senatorial District. Thank you very much, sir, for your time this morning. That's our program today. Please join us tomorrow for a fresh edition. I am Yori Folarin. Bye-bye for now.
At TVC News, wherever the big news story is happening, we're geared up to break it. TVC News, first with breaking news.
I want to comment.
Well, we begin this hour in Abuja, where the victory of President Bola Tinubu has been affirmed. We have the Vice President who is standing by live at the Court of Appeal in Abuja.
Democracy, the voice of the people, is the note that cannot be silenced.
And even in this our moment of triumph, we don't want to be triumphalists. It must be borne in mind that democracy is not a destination, it is a journey. Democracy challenges us. It tests our resolve, our determination to be the jealous custodians of the will of our people. I want to commend our leadership who have been here, our governors, our leaders from all walks of life who have been with us for well over 12 hours. We want to celebrate them, we want to thank them, and we want to thank the Nigerian public. But this is a time for unity. It's for us to shape the sword and work for the greatness of our nation. On behalf of my principal, I wish to call on Waziri Pombina Atiku Abubakar and Mr. Peter Obi, my very good friend, to join hands with us to build a new Nigeria.
Yes, sir. Thank you very much. Congratulations.
Thank you.
Chairman, sir.
Yeah.
Chairman, National Chairman, your party today emerged victorious at the tribunal, and this is just the first stage. But what does this mean for your party? How is this a validation of the vote you got at the polls?
Thank you. Really, it's a huge success, but not only for APC as a political party, but for Nigerians and for democracy, because this has shown that our judiciary is living up to expectation, and also this shows that democracy has come to stay in Nigeria. We are so much pleased with this judgment, and we are happy that all the 5 judges are unanimous in taking this very solid decision. So I believe other political parties too will welcome this development, even though there is room for appeal, but equally the same, this shows that Nigeria has come of age as far as democracy is concerned.
All right, thank you so much, sir.
Thank you.
As the chairman of the Progressive Governors Forum, sir, what does this say for your party? And let's first talk about the judiciary. How does this further strengthen that trust in the judiciary, in the judicial system?
Well, it's very clear. This is victory for our democracy. It's victory for our political system too, and also an opportunity for the world to see the kind of men and women in our judiciary. You can see the quality of judgment that was delivered today, and the judge after judge, the intellect, the strength, the mental strength we saw, the knowledge of law we saw them today display is so impeccable that there is no Nigerian that will not go home today and sleep well. Above all, we must give God the glory. Victories come from God. And to our president, I want to wish him well. I want to use this medium to congratulate him. He's a man who has come to serve, a man that is full of ideas. I see him as a creative thinker. And given the opportunity and the support of all of us, I'm sure he will take us to the right destination that Nigeria should be.
All right, then congratulations once again. Well, Ifemi, there you have it, the immediate reaction from members of the All Progressives Congress who are still basking in the euphoria of that victory here at the Election Petition Tribunal, a consensus decision of all the judges in favor of the All Progressives Congress. Later on, Celestina and I will join you to give more analysis. Over to you, Ifemi.
Let me record live for us at the Presidential Election Petition Court, where the 5 justices of the Court of Appeal unanimously, just a few minutes earlier today, indeed affirmed the declaration of Bola Ahmed Tinubu as President of Nigeria, and also dismissing the petition filed by the APM, Labour Party, and the People's Democratic Party for lacking merit and failure of petitioners to prove all allegations. I'm joined now by constitutional lawyer and senior advocate of Nigeria, Wahab Shitu. Senior advocate, thank you for staying the course. It's been a grueling 12-hour session, and I know that you have monitored election petition tribunals for years now. This particular proceeding was televised live. Is it unprecedented, the length of time, or is it a norm for a presidential petition like this?
Well, I think in the history of this country, what has happened today is really, really unprecedented. Not only has this judgment taken the length of time unprecedented in history, it is also the first time this kind of judgment will be televised worldwide, for the benefit of local and international audience. I think all stakeholders in the administration of justice should feel very proud of what our judiciary has shown today. All Nigerians should feel very proud. All lovers of democracy should also feel very proud. My own perspective is that we have shown clearly to the world that our democracy is working. We have also shown that central to our democracy is our respect for the rule of law. For me, there are no victors, there are no vanquished. For me, all those who have participated in the process are winners, because ultimately the president who has emerged from this process is the president of the entire country, and is pretense over all institutions, all authorities, all political parties, all opponents. They will now come under his own umbrella as the father of the nation. So I think the way to go is not to malign, abuse, or scorn anybody as losers. I think the way to go is for us to see what has happened today as a collective victory. And I think what we should also see clearly displayed today is that we have seen how the judiciary works.
It also would seem that the judiciary had a point to prove, saying how detailed the justices went in reeling out all of the judgments that we saw in the past 12 hours. But what's your thoughts of the judgment per se? Are you surprised by the outcome?
Well, I'm not altogether surprised at the outcome, because I know that judgments, I know how the judiciary functions. A lot of people who make commentaries in the public space do not know how the judiciary works, or perhaps they do not take time to find out the workings of the judiciary. And this is what has been shown today. The judiciary works on the basis of facts. The judiciary also works on the basis of evidence. The judiciary works on the basis of proof. The judiciary works on the basis of findings. The judiciary works on the basis of settled legal principles. And then the judiciary also works on the basis of conclusions arising from those settled legal principles. You can see that the judges are detached. The judges have shown courage. They have shown deep knowledge of our jurisprudence. You see, if, for instance, and at this level, this is the level where this is the Court of Appeal in presidential election is like the Court of First Instance, where evidence is taken, where documents are admitted, where witnesses are called and give evidence. So and this is the stage where evidence is evaluated, because the justices take evidence from witnesses and all that. When the matter moves from this stage, evidence is not taken. If the matter moves from this stage to the Supreme Court, witnesses are not called. Documents are not tendered at the Supreme Court. What the Supreme Court will look at is the record of proceedings from the Court of Appeal. So, and they will see whether, arising from the record of proceedings from the Court of Appeal, whether documents were properly admitted, whether evidence was properly taken, and whether conclusions were properly reached, arising from legal principles. I'm so happy. I celebrate the judiciary Because before now, attempts were being made to rubbish our judiciary, to malign our judiciary, to scandalize our judiciary unfairly. And if we succeed, if we had succeeded, if the detractors had succeeded, that would have been an end to democracy. Because central to the democratic tradition is the judiciary, is respect for the judiciary. If we don't respect the judiciary, anarchy looms. So I'm very happy today that the judiciary has risen to the occasion to show that we are men and women of sterling integrity. We are unbiased umpires. We deploy the law to the facts and evidence as presented.
Well, that's how you see it as a senior advocate.
Yes.
There are varied reactions to what we've seen in the past hours. For instance, the Labour Party has already rejected the judgment, saying that it will decide its next step after consulting with lawyers. But let's talk about how unique the unanimous decision is for a case of this stature, and how much credence this has brought to today's verdict, the fact that all of the 5 justices seem to have seen it the same way.
When you have a unanimous decisions, such as you have had, it means that judges, all the justices who saw witnesses testify, who saw evidence laid, who saw documents tendered, who applied the law, saw all of this in the same way. They agreed unanimously with the conclusion reached. This is a unanimous decision. It is not just all of them agreed unanimously on the preliminary applications. There was no dissent. They also agreed unanimously on the merits of the case at this stage of the proceedings. So the fact that it's a unanimous decision at this stage of the proceedings makes it watertight at this stage of the proceedings. But I will tell you that this is like the semi-final stage of the proceedings. The final stage of the proceedings is the Supreme Court. You said the lawyers said they are going to decide their own line of action.
No, the party said it will meet with...
Yes. I hope that whatever the parties then decide to do will be a decision on the part of constitutionalism, a decision on the part of respect for the rule of law. And what is that decision? That decision that follows, constitutional, approaches and rule of law approach will be a decision we say, oh, we want to appeal, or we decide not to appeal, not a decision that...
Hold on for a minute, senior advocate. Let's bring in another lawyer on this conversation. Olaika Ola Daniels joins us live via Zoom. Mr. Daniels, thank you for joining us on the news this hour. The Court of Appeal made some landmark decisions on very critical issues in the preceding hours, particularly about some issues that have been raised in the past 6 months following the 2023 election. I want to hear your thought about the dismissal of the 25% votes required for a president to emerge in the FCT. The Court of Appeal is saying Abuja is like every other state with no special status. How satisfactory for you is this court's interpretation of Section 132 of the Constitution?
Well, I would say that from time before now, some of us, we have said that the people, they were clamoring for some interpretation of that particular section. They're just being mischievous, in a way, because it's clear, and we have said it, that FCT does not have a particular special status. It's just one of them, and it's so clear in the Constitution when it said "and." So you can have 25% in FCT. You do not need to have 25% in FCT to win the election. It's clear, ab initio. So people that are clamoring on it, they're just looking for a way. When you don't have a case and you just want to put all sorts that you think you can use to manipulate the people, I think that is that is actually as a result of some of the issues brought. Looking at 25% as one of an issue to cancel the election.
I hear you, Mr. Daniels.
Know that is just.
Let me hear the senior advocate's thoughts on this. Will this decision by the Court of Appeal lay that issue to rest in future election disputes? Because I hear you say there is still the Supreme Court that can...
Well, as far as the law is concerned, today, the law is as pronounced by the justices of the Court of Appeal today, until the contrary. And so I'm happy that this controversy, as at this stage, is settled. I'm more particularly happy for our president, President Bola Ahmed Tinubu. This judgment has, like Pontius Pilate, washed him clean. The justices of the Court of Appeal have given him a clean bill of health, that he is not a criminal, that he is not a drug addict, that he has not been convicted before, that he has not been arraigned for any offense, he has not been indicted. So, lovers of democracy, lovers of this country, should now hold their heads high, that we have a president who is above board, who is credible, who is integrity driven, who is integrity personified, and who can lead the most popular black country in Africa, the largest black country in Africa. Because before this judgment, some of us are worried that our president and the chairman of ECOWAS, somebody who's leading the largest, most populous black African nation, is being tarred with this kind of stigma. Today, what the Court of Appeal has done is to wash our president very clean. And we now know that we can all now rally around him and ensure that he succeeds in his assignment.
Mr. Ola Daniels, the court today also ruled that INEC is not mandated to electronically transmit or transfer election results, and that glitches experienced during the February presidential election wasn't employed to manipulate results. As a matter of fact, it says the petitioners couldn't prove, without reasonable doubt that it was a manipulation plot. But let's talk about the impact that the Electoral Act of 2022 has had on the Court of Appeal's verdict today, and whether or not you think it's an improvement on what we've had in the past.
Yeah, we must understand that the court is not a Father Christmas, and will not give you what does not exist or what you have not asked for. And looking at the Electoral Act is clear, and we have said this also before the court even made his own judgment on it, that look, the Electoral Act is clear. The uploading, the Electoral Act does not give any room for it. There is no law under the Electoral Act that says that must be done. It is a guideline. There's difference between guideline rules and the law. Law is different from it. So a lot of people, like I said, when you are just being mischievous, you know the truth. And that is why it's so sad that today the Court of Appeal had to teach a lot of people a lot of lessons. The Court of Appeal had to lecture a lot of lawyers because we know the truth. The Electoral Act is clear on this, and with the improvement that has done, thankfully, well, maybe in future, we may need to consider that, but then we may need to go back to the legislative arms of government to see how the law can be repealed to fit in those provisions if we want to make them part of the law that exists and that guide the entire election. But as this last election, what INEC did is not out of place. If you have plan A, you must have plan B. And if it is not the law, if it is the regulations, if it is guidelines, anything can happen. An hiccup can happen, and you cannot then use that particular itch to then saying you want that the election is not worthy, the election is not free, the election is not fair, just because a particular guideline wasn't used for that particular election. The question is, has any law been breached? Has any law been violated? No. And the Court of Appeal made it clear in his judgment. He said, we are not supposed to wait till the time court will be telling us the right thing. We know it. And I just hope that lawyers, both our seniors and lawyers should know the truth and they should uphold it. And we should not just because we need to, probably for one reason or the other, for different motives, we just want to waste the time of the court. We want to waste the time of Nigerians. We just want to create chaos where there is none. For me, the Electoral Act has really made an improvement, and we all know, we can see what Beavers did. Thankfully, we appreciate Beavers.
I hear you, Mr. Daniels. Let me hold you for a minute. Let's turn our attention very quickly to the Court of Appeal in Abuja, where our judiciary correspondent, Celestina Area, is standing by. Celestina, it's been a long wait, over 12 hours covering this story. Let's begin with the mood, in the court during these proceedings. We saw some people doze off, some walked out at some point, a few cheers here and there. What did you see that the cameras did not capture?
Well, Nifemi, it's a day to celebrate as far as Nigerian is concerned. In this very case, there is no victor, there is no vanquish, because all that will happen today is channeled to promote democracy of the country. Yes, the counsel to the PDP told the court after judgment was delivered that he intends to get the copy of the judgment as soon as possible, because yes, they also have a right to appeal to the Supreme Court that the Presidential Election Petitions Court, which is the Court of Appeal, is the court of first instance as far as a presidential election is concerned. So he asked for the copy of the judgment because the day start counting from today, being the day the judgment was delivered, as when their course of action arose, and the Supreme Court has 60 days to deliver judgment. But by and large, the parties of supporters of the APC, as well as APC governors that were here present and dignitaries here present, were very happy. And the position they've always canvassed was also the position held by the court today. First, that the FCT has no special status. The FCT is like every other state. So credence or priority should not be given to the FCT, or FCT should not be a determined state as far as presidential election is concerned. And the court also found out that the IRF portal on the Beavers is just to use to scan voters, and the IRF portal is not a collation center. That the fact that INEC did not upload the results, real-time results to the IRF portal, did not in any way impair the outcome of the election. So there are a lot of issues. The issue as to double nomination alleged against the vice president. This was also filed by the APM, their sole ground, and also filed by the Labour Party and the PDP. The court first decided that of the APM and adopted that position in the other various position. The court held that the vice president was not in any violation of any constitution or any laws, and is not in breach of double nomination, or is not in contempt of any double nomination. So these were the positions of the court today.
How are the petitioners reacting to the verdict? Celestina, I'm wondering if you have any reaction yet from any of the petitioners in court today.
Well, we're expecting them to speak to newsmen after the proceedings, but they all stepped out with believing that maybe they probably were not pleased with the judgment. But we only spoke to counsel from the APC and the president, and also supporters of the president and the APC. But by and large, you would agree with me that the justices took their time, because we all have been monitoring these proceedings, the judgment for today. They took their time to decide the case with the plenary objection and on the merit, to ensure that justice is done to this petition. They don't want to be found wanting. They told the courts at the inaugural sitting that they would do justice, so that nobody will hold them responsible for injustice. So they really did their best today. They also, first thing first, we should recall that they expunged some witness statements of the witnesses brought by Labour Party and also that brought by the PDP, being the fact that when pleadings were made, the petition was filed, the Labour Party and the PDP did not submit the complete list of witnesses. They later submitted the list of witnesses that was subpoenaed, and this the tribunal said is in contravention of Section 285 of the Electoral Act, which says that all pleadings must be brought before the court at the time of filing. So the tribunal found their statements to be incompetent. So outside the 13 witnesses called by the Labour Party, only 3 of their witnesses were credible, as 10 were discredited by the court. The Labour Party called, the PDP called 27 witnesses, the court struck out 13 witnesses they called. So this goes to show that the court tried to give a precedence for how pre-election matter and respect to the presidential election should be conducted and how it should go. The parties not need to come to the tribunal and dump documents before the court. The pleadings should be made and documents should be tied to the claim of every petitioner. The PDP and the Labour Party brought voluminous document before the court. No pleadings were made to this document. No evidence was made to this document. And also the court also determined the issue of the EU report and the ECOWAS report tendered by the Labour Party and the PDP in trying to prove their case. The court said that the maker of those documents were not brought to authenticate this document. As nobody could plead to this document, they bought a mere sheet of paper. So a lot of issues were resolved today at the trial court, which is the Court of Appeal, and we know at the Supreme Court, witnesses will not be called.
Scenario live for us at the Presidential Election Petition Court in Abuja. Thank you for the great job you have been up to since morning. Senior Advocate of Nigeria and Constitutional Lawyer Wahab Shitu is right here with me in the studio. Talking about the EU and ECOWAS report, Justice Moses Ugo particularly mentioned that there are mere sheets of paper if they cannot be demonstrated. It was also quoted to have said that if there was any manipulation of results in this election, it was done in favor of the Labour Party. We keep hearing the petitioner failed to establish, and then we are seeing many of these petitions being strike out. Is there a sense to which you are disappointed in how well the petitioners have been able to prove their case in this
I will not say
matter?
I'm disappointed. I will say that I'm impressed, because that is the way the law works. Election petitions are sui generis. What does that mean? They are special kind of proceedings on their own, and then there are specialized rules for the conduct of these election petitions. I can speak to you from a sense of authority. At least I handle about 4 or 5 election petitions in Lagos here. And to God be the glory, I was victorious in all those elections. So I'm familiar with the rules. What they are saying is that if you want to bring any document, whether EU report or whether any documentary evidence, you must tender those documents through the maker of those documents, who alone will be able to speak to the documents and demonstrate the documents to the court, where you just tender them without the maker being called to come to the documents. They are called documentary hearsay. So this is the way the Court of Appeal has looked at it and have made its conclusions. Except this is overturned by the Supreme Court, which is also the highest court in the land. This is the law as it is now, demonstrated through settled cases. I was listening to the commentary from my respected lawyer from Abuja, who is also commenting on the proceedings. And I just want to say that this is not a forum to condemn any of the lawyers who have participated in this process, whether lawyers for the petitioners or lawyers for the for the respondents. If you look at the lawyers who were assembled today, they represent some of our very best. And what this outcome has demonstrated is that it has deepened our jurisprudence. When lawyers participate in the process of deepening of our jurisprudence, whether for or against,
could there be challenges?
Such lawyers should be commended.
Could there be challenges with the interpretation of the Electoral Act, saying that it was passed just a few months to the general election this year?
Well, there's no challenge. The question is to ask is whether it was duly passed. And the answer is yes. Whether it's recognized as the law regulating the conduct of elections in Nigeria today, the answer is yes. You know, I don't think there's any dispute about the applicability of instant laws.
Because many of these provisions were tested at the Court of Appeal.
Were tested. That is what I'm telling you.
These lawyers went to court with the backing of this law, which has now not given them the desired result.
So this law now, this judgment is not the Quran or the Bible of election petition litigation in Nigeria. Anybody who wants to be involved in the process of litigation relating to election petition must read this judgment. All aspects appear covered by some of our best brains in the land. And I think, as a member of the INAPA, I feel very proud of what has happened today.
Don't forget that there's still the Supreme Court that will test.
No, what I'm saying that I say at this stage,
yes,
when a court, whether High Court, pronounces, that is the law at that stage. When the Court of Appeal then also pronounces, that is the law at that stage. So the law, as at today,
as at now,
all
right, I get you.
What has been pronounced.
Let me hear Mr. Oladan's thoughts out here. Another interesting ruling we had today is about the much talked about allegations of charges against the president in the United States, and the Court of Appeal said the petitioners failed to prove that President Tinubu was convicted for money laundering in the U.S., and that there was no criminal charge filed against the president in the U.S. They also added that the president didn't go through a criminal trial in the United States. Talk to us about the implication of this judgment on what seems to have characterized pre-election campaigns and the baggage he even carries up until now.
With due respect also to our seniors, like the sir stated, with due respect to that, if I'm a lawyer and I've not done my work well, anyone can say I've not done well. If before now, some of us, when the issue of conviction, allegation of criminal issues against Mr. President, some of us, we raised series of questions, and we asked them to produce the conviction. We asked them to even produce the court proceedings. We asked them to give us suit number in which he was arraigned and convicted. None of them could produce this. Yet, these are some of the things some of our lawyers took to court to disqualify all the petitioners. Okay, maybe I will leave the lawyer out of it. Some of these are the things the petitioner took to court against Mr. President. Look, what are the facts? Courts deal with law and facts. There's no rumor, there's no hearsay and all that. So if you do not have that, why will you come to court to seek such prayer that based on this allegation, in quote, someone should be disqualified, or someone is not fit and proper, or someone is not qualified to run for presidency, when you do not have facts? When they were in court, and we all heard the judgment of the court today. As to some of the evidence that's supposed to be presented, how can someone be giving evidence on Amazon.com? How? I mean, there are some things that we had today were absurd. So that is the reason why some of us are not happy with some of the lashes we received from the tribunal, and to some of the things we did not do right. So if you do not have a conviction, you do not have any evidence to say somebody was tried and convicted, and then come just bear on allegation or rumor or what you think you believe in your head. And we all know the law. The Evidence Act is clear on evidence. So I believe these are senior advocates, even if the petitioners, if clients have come to you with emotions, with whatever they have, to present their case before you, you should know better. And that is the reason why some of us are not happy the way it has turned to be.
It will seem the senior advocate doesn't want you to come so hard on your learned colleagues.
I said I'm trying as much as I can not to come so hard on them. But unfortunately, this is, a client has come to you. He has presented his case to you. You know better. You're a lawyer. You should be able to advise your client. Not because, of whatever you want, and then you just take everything over and you are in court. We know better.
I really wish we could move away from that to explore some other important decisions that have been made by the Court of Appeal today. I know you want to quickly respond to that.
Well, I don't want to appreciate the concern of my learned friend on the other side, but to say that our colleagues who have taken the matter to court have done no wrong. They are just doing their duty. And what has benefited from this process is our jurisprudence. Today, we now know that our president is very clean, our president is not an ex-convict, that our president does not have any extra baggage to carry. I'm particularly very happy. If this opportunity did not arise, the Court of Appeal will not have put the matter to rest. Now, let me quickly also say that I'm happy on the distinction made by the Court of Appeal today between civil forfeiture and criminal forfeiture. Civil forfeiture arising from proceedings in rem, and criminal forfeiture arising from proceedings in persona. When proceedings are in rem, the defendant is not brought to trial, no charge is read to him, is not indicted, it is only the asset that is attached, and that does not amount to conviction or guilt under our law. But that is any student of international law who understands how the international law actually works. We know that what the Court of Appeal has stated today represents the law. The fine distinction between civil forfeiture and criminal forfeiture. I'm happy that my president, the president of the most populous black African country, I'm very happy that he has never been indicted. He has no charge has ever been read against him. He has never been brought to any trial. He has never been convicted. I'm happy. For me, I think the president of the country and all Nigerians should celebrate what has happened today.
All right.
And that any attempt anywhere by anyone until the contrary is arrived at to label our president with any such stain or stigma is a contempt of court. It will be a criminal action. Because until now, we cannot say for certain what is the position. But the Court of Appeal has laid the matter to rest today that allegation.
And we have a position of the law on the matter. Mr. Daniels, let me get your thoughts on the fine to be paid by some of these political parties in their millions of naira. The Presidential Election Petition Court has awarded cost for filing some frivolous cases here. What does it actually represent? Because some people will say it's unfair to lose a case of this magnitude and still have to pay fine.
Yeah, well, for me, I think it's a good development. The welcome development. It has happened before, and this is not the first time. You remember when Supreme Court slammed our senior advocate some fines to pay because of some frivolous applications that they brought before the court. I think this is to checkmate litigants and to let them know, look, court is not a place you come to waste its time. Court is not a place you can bring anything to because you think, oh, you just want to go. You know that this thing will fly. You have not even done your own work. You have not done your research. And you come to court to think that you can waste the time of the court. I think it's a good development so that it will discourage people that don't add anything substantive. People that do not add any iota of seriousness or any iota of valid cases to court, and to then come. And there are a lot of files. There are a lot of cases before the Court of Appeal which I know. But now we have to, even Supreme Court and several courts. Then when people go to court, you see some of these politicians particular matter to deal fiction. Just because they want to favor them, the other one, once one does not favor them, please do someone with favor. It's same.
Hold that thought, Mr. Ola Daniels. We'll get back to you shortly. Senior Advocate, I'll also get your reaction shortly. But let's get back to the Presidential Election Petition Court, where our State House correspondent Femi Akonde is standing by. Femi, you spoke earlier with the Vice President, I believe the APC chairman, and also the chairman of the Progressive Governors Forum. What more reactions are you getting from stakeholders in this case?
Well, Femi, a lot of these stakeholders are excited. Well, that excitement, I will tell you, is restricted to the camp of the APC, for the Labour Party and the People's Democratic Party, and including the Alliance People's Movement, that's the APM. They are not excited. A lot of them are disappointed in the judgment of the Election Petition Tribunal. But, well, they still believe, they are still clinging on to hope, believing that, well, they might still again have their day at the Supreme Court, and probably the judgment might go in their favor. But we're already getting reactions from all camps. The President Bola Ahmed Tinubu, who is far away in India attending the G20 summit, has already reacted to this judgment by the Presidential Election Petition Tribunal. He is also calling on Nigerians to unite and promising and committing more to improving good governance and promoting national development in the country. But for the Labour Party, they have rejected this judgment in its entirety. They have released a statement even before the overall judgment was read here at the tribunal. The Labour Party, the Labour Party statement was already circulating. We are already seeing statements from bigwigs of the Labour Party on social media and in other forums talking about this decision of the Presidential Election Petition Tribunal. Moving forward, this discussion, this subject will dominate discussions in the coming days, especially for lawyers who, a lot of them got serious bashing from the Presidential Election Petition Tribunal. So there's a lot for them to chew on coming from the judgment. A lot of them will also approach the court tomorrow to get the copy of the judgment as was read today. Nifemi.
Reactions from the APM and the Labour Party. Have we heard anything yet from the People's Democratic Party, Femi?
Well, officially, the People's Democratic Party is still silent. They are yet to make any official statement with regards the judgment of the Presidential Election Petition Tribunal. We believe that they might still be studying that judgment, talking to their lawyers to decide their next line of action. It is when that is done, due diligence would have been done on their part before they can then come to the press with a formal statement. Nifemi.
Vice President was in court. We understand that the president is away in India. But unlike the Labour Party and PDP presidential candidates who usually would be present in person at the court, they were conspicuously absent today. How are stakeholders reacting to this?
Yes, indeed. It raised a lot of curiosity because in the build-up to this, we have seen them come to court while their petitions were still being heard. They came to court several times. Atiku has been in court. Peter Obi has been in court several times. And, everyone had expected to see them in court today. When the court opened, we saw people from the All Progressives Congress, we saw the Vice President, we saw the National Security Advisor, Nuhu Ribadu, we saw the Chief of Staff to President Bola Tinubu, Femi Gbajabiamila. Everyone was waiting to see Peter Obi of the Labour Party, waiting to see Atiku Abubakar of the People's Democratic Party. But, waited, and they did not show up. And no reason has also been given as to why they decided to stay away from court on this big day, Judgment Day, when their fate and the fate of their party will be decided. We do not yet know why they decided to stay away from court. But, they had representatives in court too. We saw members of their political party in court representing them, sitting all through, listening to the judges as they read out the judgments, if I may.
They're live for us at the Presidential Election Petition Court in Abuja. Let's ask the senior advocate. You have represented quite a number of these politicians in the past, I believe. Even in this dispensation. Is there a sense to which lawyers, who represent petitioners in this case, could have an idea of which way the judgment could swing and tell their principals, you know what, stay at home today?
I don't think the absence of any of the bigwigs mentioned has anything to do with speculation about the outcome.